transparent about the factors animating the entry of nolle prosequi in some cases and the withdrawal of others is not only because I want to avoid accusations of partiality and or capitulation to political pressure, but also to comply with the constitutional requirements stated in Article 296 of the Constitution. More so, in the best ethics of the legal profession, every lawyer is mandated to act in the best interest of his client, and no lawyer worth his salt, his or her salt, will purport to act in the best interest of the client by doing so on the blind side of the client. As Attorney General, my only client is the Republic of Ghana, represented by its sovereign people. And as stated above, I intend to provide the reasons for my decisions in the cases in which I have either entered a nolle prosequi or withdrawn the charges laid against the accused persons. And I do so to my fellow citizens who have entrusted the power to me through the President of the Republic. Before I proceed to assign the reasons for my decision in each of the cases, I wish to crave your indulgence to provide a brief explanation of the technical difference between the entry of a nolle prosequi and the withdrawal of charges. The power to enter a nolle prosequi is contained in Section 54 of the Criminal and Other Offences Procedure Act 1960, Act 30. Pursuant to this provision, the Attorney General may enter a nolle prosequi at any stage of a criminal trial. The statute does not itself require the Attorney General to provide any reasons for his decision to enter a nolle prosequi in any proceedings. However, as I have made clear above, the constitutional principles in Article 296 impose an obligation on the Attorney General to be candid in the exercise of his discretionary power, and I cannot fathom how one can be candid without explaining one's actions. When a nolle prosequi is used by the Attorney General to terminate proceedings in a criminal trial, he reserves the right to bring fresh charges against the accused persons in the future. In contrast, the Attorney General may terminate criminal proceedings by withdrawing the charges against an accused person pursuant to Section 59 of the Criminal and Other Offences Procedure Act 1960, Act 30. Where the charges are withdrawn after the prosecution has closed its case, then the legal effect of the withdrawal is that the accused is deemed to have been acquitted and discharged. In other words, that accused cannot be brought back and tried on the same facts or for the same offenses. So in all the cases in which I have withdrawn the charges against the accused persons and in which the prosecution has closed its case, those accused persons are considered to have been acquitted and discharged. Ladies and gentlemen of the media and fellow citizens, my decision to terminate the criminal trial was animated in the main by three factors.